Jurisdiction over the subject matter or nature of the action. It is important that a court or tribunal should first determine whether or not it has jurisdiction over the subject matter presented before it, considering that any act that it performs without jurisdiction shall be null and void, and without any binding legal effects. A void judgment for want of jurisdiction is no judgment at all, and all acts performed pursuant to it and all claims emanating from it have no legal effect. So jurisdiction over the subject matter is very important. Jurisdiction over the subject matter or nature of the action. Subject matter jurisdiction is defined as the authority to hear and determine cases of the general class to which the proceedings in question belong, and is conferred by the sovereign authority which organizes the court and defines its powers. What is the difference between jurisdiction and exercise of jurisdiction? Jurisdiction is the power and authority to hear, try, and decide a case. It does not depend on the regularity of the exercise of that power. It is conferred by substantive law, such as BP 129, or by other statutes. Okay, on the other hand, the manner of the exercise of jurisdiction is, unless otherwise provided by the law itself, governed by the rules of court or by orders which are from time to time issued by the Supreme Court. Jurisdiction is the authority to decide a case and not the decision rendered therein. Where there is jurisdiction over the person and the subject matter, the decision on all other questions arising in the case is but an exercise of jurisdiction. Now, what is the difference between error of judgment and error of jurisdiction? The errors which the court may commit in the exercise of jurisdiction are merely errors of judgment, which are the proper subject of an appeal. On the other hand, error of jurisdiction means lack of authority to decide a case or grave abuse of discretion amounting to lack or excess of jurisdiction, which is the proper subject of a petition for certiorari. So the distinction is clear. A petition for certiorari seeks to correct errors of jurisdiction, while a petition for review seeks to correct errors of judgment committed by the court. Okay. So where a court has jurisdiction over the person and subject matter, as I've mentioned, the decision on all other questions arising in the case is an exercise of that jurisdiction. Consequently, all errors committed in the exercise of such jurisdiction are merely errors of judgment, which is correctable by appeal. Errors of judgment. Errors of judgment include errors of procedure or mistakes in the court's findings, misapplications of facts and evidence, and whatever flawed conclusions is an error in judgment, not of jurisdiction, and therefore not within the province of a special civil action for certiorari. Erroneous conclusions based on evidence do not, by the mere fact that errors were committed, rise to the level of grave abuse of discretion. Because, as I've mentioned, once jurisdiction is acquired, or where there is jurisdiction, any act in accordance with that jurisdiction is but an exercise of jurisdiction, and any error committed through the exercise of jurisdiction is an error of judgment. Okay, for as long as a court acts within its jurisdiction, any supposed error committed in the exercise thereof will amount to nothing more than an error of judgment, reviewable and may be corrected by a timely appeal. All right. The rationale of this rule is that when a court exercises its jurisdiction, an error committed while so engaged does not deprive it of the jurisdiction being exercised when the error is committed. Otherwise, every mistake made by a court will deprive it of its jurisdiction, and every erroneous judgment will be a void judgment. See, for example, for every act committed by the court, if it becomes error of jurisdiction, it strips off the court of its jurisdiction, which it really acquired by virtue of the law or by the statute conferring jurisdiction to the court. The court's jurisdiction over the nature and subject matter of an action is again conferred by law. A court's jurisdiction over the subject is determined by the relevant allegations in the complaint, the law in effect when the action is filed, and the character of the relief sought, irrespective of whether the plaintiff is entitled to all or some of the claims asserted therein. Allegations in the complaint comprise a concise statement of the ultimate facts constituting the plaintiff's cause of action. So once vested by the allegations in the complaint, jurisdiction also remains vested irrespective of whether or not the plaintiff is entitled to recover upon all or some of the claims asserted therein. General rule. The general rule is that the court should only look into the facts alleged in the complaint to determine whether a suit is within its jurisdiction. While there may be instances, however, when a rigid application of this rule may result in defeating substantial justice or in prejudice to a party's substantial right. So, there are exceptions. In these instances, in the first case, in the Mar Copper Mining Corporation versus Garcia, the Supreme Court allowed the RTC to consider, in addition to the complaint, other pleadings submitted by the parties in deciding whether or not the complaint should be dismissed for lack of cause of action. And in another case, Guaranteed Homes Incorporated versus Heirs of Valdez, the Supreme Court held that the factual allegations in a complaint should be considered in tandem with the statements and inscriptions on the documents attached to it as annexes or integral parts. In the case of Tumpag versus Tumpag, the Supreme Court held that we find reason not to strictly apply the above-mentioned general rule, which is the rule that allegations in the complaint determine jurisdiction. The court said that it considered the facts contained in the declaration of real property attached to the complaint in determining whether the RTC had jurisdiction over the petitioner's case. A mere reference to the attached document could facially resolve the question on jurisdiction and would have rendered lengthy litigation on this point unnecessary. Jurisdiction over the subject matter is not acquired through administrative issuances or court orders. It is not acquired by agreement, stipulation, waiver, or silence. Any decision by a court without a law vesting jurisdiction upon such court is void. It cannot be acquired through a waiver or enlarged by the omission of the parties or confirmed by the acquiescence of the court, and may be raised at any stage of the proceedings, even before or even for the first time on appeal. The jurisdiction of a court over the nature of the action and the subject matter thereof cannot be made to depend upon the defenses set up in court or upon a motion to dismiss, for otherwise the question of jurisdiction would depend almost entirely on the defendant. So see, for example, a plaintiff or petitioner files a complaint or petition against a defendant. So the rule is that the allegations in the complaint determine the jurisdiction over the subject matter. Or in the reverse, jurisdiction over the subject matter is determined by the allegations in the complaint. It would be ridiculous if the defendant or the respondent could be able to say that the court has no jurisdiction over the subject matter by alleging it in a motion to dismiss or an answer. So the rule is, jurisdiction over the subject matter is not determined by the defenses set up in court or by the allegations in a motion to dismiss. The Congress has the power to define, prescribe, and apportion the jurisdiction of various courts, and courts are without authority to act where jurisdiction has not been conferred by law. Statutory conferment of jurisdiction is different from the power of the court to designate special courts. As I have discussed previously, in Gonzalez versus GJH Land Incorporated, the Supreme Court ruled that the power of the Supreme Court to designate special courts has nothing to do with the statutory conferment of jurisdiction, because primarily the court cannot enlarge, diminish, or dictate when jurisdiction shall be removed. As a general rule, the power to define, prescribe, and apportion jurisdiction is a matter of legislative prerogative. Jurisdiction over the subject matter of a case is conferred by law, whereas a court's exercise of jurisdiction, unless provided by the law itself, is governed by the rules of court or by the orders issued from time to time by the Supreme Court. In Lozada v. Bracewell, the Supreme Court held that the matter of whether the RTC resolves an issue in the exercise of its general jurisdiction or of its limited jurisdiction as a special court is only a matter of procedure and has nothing to do with a question of jurisdiction. How to determine whether the court has jurisdiction over the subject matter of a case? Let us discuss an example. Foreclosure of mortgage. So, the RTC has exclusive original jurisdiction in actions incapable of pecuniary estimation, and also real action when the value of the property exceeds 20,000 pesos outside Metro Manila or exceeds 50,000 pesos in Metro Manila. So, a real action is an action involving title to real property, which means that the plaintiff's cause of action is based on a claim that he owns such property or that he has the legal right to have exclusive control, possession, enjoyment, or disposition of the property. Now the question is foreclosure of mortgage an action incapable of pecuniary estimation or a real action? Let us discuss the case of Roldan v. Spouses Barrios, GR number 214803, April 23, 2018. The facts of this case are as follows. The allegations and relief sought in petitioner's action for foreclosure of mortgage showed that the loan obtained by respondent Spouses Barrios from petitioner fell due and they failed to pay such loan, which was secured by a mortgage on the property of the respondent spouses, and prayed that in case of default of payment of such mortgage indebtedness to the court, the property be ordered sold to answer for the obligation under the mortgage contract and the accumulated interest. The ruling of the Supreme Court. The Supreme Court held that the essence of a contract of mortgage indebtedness is that a property has been identified or set apart from the mass of the property of the debtor-mortgager as security for the payment of money or the fulfillment of an obligation to answer the amount of indebtedness in case of default in payment. Foreclosure is but a necessary consequence of non-payment of the mortgage indebtedness. So in a real estate mortgage, when the principal obligation is not paid, when due, the mortgagee has the right to foreclose the mortgage and to have the property seized and sold with a view of applying the proceeds to the payment of the obligation. So the Supreme Court held, therefore, the foreclosure suit is a real action so far as it is against the property and seeks the judicial recognition of a property debt and an order for the sale of the rest. Jurisdiction and payment of docket fees. Consistent with the Section 1, Rule 141 of the Revised Rules of Court, which provides that the prescribed fee shall be paid in full upon the filing of the pleading or other application which initiates an action or proceeding, the well-entrenched rule is to the effect that a court acquires jurisdiction over a case only upon the payment of the prescribed filing and docket fees. Lack of jurisdiction over the subject matter. It is important that a court or tribunal should first determine whether or not it has jurisdiction over the subject matter presented before it, considering that any act that it performs without jurisdiction shall be null and void, correct, and without any binding legal effects. A void judgment for want of jurisdiction is no judgment at all. All acts performed pursuant to it and all claims emanating from it have no legal effect. Lack of jurisdiction over the subject matter or the nature of the action cannot be made to depend upon the defenses set up in court or upon a motion to dismiss, for otherwise, as I have mentioned earlier, the question of jurisdiction would depend almost entirely on the defendant. Now, Whenever it appears that the court has no jurisdiction over the subject matter, the action shall be dismissed, even motu proprio. Okay, the general rule is that a court's lack of jurisdiction may be raised at any stage of the proceedings, even on appeal, for the same is conferred by law, and lack of it affects the very authority of the court to take cognizance of and to render judgment on the action. It applies even if the issue in jurisdiction was raised for the first time on appeal or even after final judgment. The fact that lack of jurisdiction over the subject matter is raised for the first time on appeal is actually of no moment. Remember that under Section 1, Rule 9 of the Revised Rules of Court, defenses not pleaded either in a motion to dismiss or in the answer are deemed waived, except lack of jurisdiction, litis pendentia, res judicata, and prescription, which must be apparent from the pleadings or the evidence and record. So in other words, the defense of lack of jurisdiction over the subject matter may be raised at any stage of the proceedings, even for the first time on appeal. In fact, the court may motu proprio dismiss a complaint at any time when it appears from the pleadings or the evidence and record that the lack of jurisdiction exists. Let's talk about the exception, which is the principle of jurisdiction by estoppel. The party raising defenses to the complaint, actively participating in the proceedings by filing pleadings, presenting its evidence, and invoking its authority by asking for an affirmative relief, is deemed estopped from questioning the jurisdiction of the court. This leads us to the landmark case of Tiham versus Sibong Hanoy, GR number L-21450, April 15, 1968. This case discussed the principle of jurisdiction by estoppel. The facts of this case are as follows. Spouses Serafim Tiham and Felicitas Tagalog commenced civil case number R-660 in the Court of First Instance of Cebu against the spouses Magdaleno Sibong Hanoy and Lucia Baguio to recover from them the sum of, take note, 1,908 pesos. After trial upon the issues thus joined, the court rendered judgment in favor of the plaintiffs, and after the same had become final and executory, upon motion of the plaintiffs, the court issued a writ of execution against the defendants. The writ having been returned unsatisfied, the plaintiffs moved for the issuance of a writ of execution against the surety's bond, against which surety filed a written opposition. Subsequently, the surety moved to quash the writ on the ground that the same was issued without the required summary hearing provided for in Section 17 of Rule 59 of the Rules of Court. As the court denied the motion, the surety appealed to the Court of Appeals from such order of denial and from the one denying its motion for reconsideration. Within the time to file a motion for reconsideration, the surety filed a pleading entitled Motion to Dismiss, alleging substantially that appellee's action was filed in the CFI Cebu on July 19, 1948 for the recovery of the sum of 1,908 pesos only. That a month before that date, RA number 296, otherwise known as the Judiciary Act of 1948, had already become effective. Section 28 of which placed within the original exclusive jurisdiction of inferior courts all civil actions where the value of the subject matter or the amount of the demand does not exceed 2,000 pesos, exclusive of interest and costs. And then that the Court of First Instance, therefore, had no jurisdiction to try and decide the case. So that is the allegation of the surety. Upon these premises, the surety's motion prayed the Court of Appeals to set aside its decision and to dismiss the case. The Court of Appeals resolved to set aside its decision and to certify the case to the Supreme Court. So what did the Supreme Court say? It is an undisputed fact that the action commenced by appellees in the Court of First Instance of Cebu against the Sibong Hanoy spouses was for the recovery of the sum of 1,908 pesos only. an amount within the original exclusive jurisdiction of inferior courts at that time in accordance with the provision of the Judiciary Act of 1948, which had taken effect about a month prior to the date when the action was commenced. The Supreme Court held that true also is the rule that jurisdiction over the subject matter is conferred upon the courts exclusively by law, and as the lack of it affects the very authority of the court to take cognizance of the case, the objection may be raised at any stage of the proceedings. However, considering the facts and circumstances of the present case, the Supreme Court held that we are of the opinion that a surety is now barred by laches from invoking the plea at this late hour for the purpose of annulling everything done before the case with its active participation. As already stated, however, considering the facts and circumstances of the case, the Supreme Court held that we are of the opinion that the surety is now barred by laches from invoking the plea at this late hour for the purpose of annulling everything done heretofore in the case with its active participation. The Supreme Court held that the action was commenced in the Court of First Instance of Cebu on July 19, 1948, that is almost 15 years before the surety filed its motion to dismiss on January 12, 1963, raising the question of lack of jurisdiction for the first time. It has been held that a party cannot invoke the jurisdiction of a court to secure affirmative relief against its opponent, and after obtaining or failing to obtain such relief, repudiate or question that same jurisdiction. By way of explaining the rule, it was further said that the question whether the court had jurisdiction over the subject matter or of the parties was no longer important in a cited case, because the party is barred from such conduct, not because the judgment or order of the court is valid and conclusive as an adjudication, but for the reason that such a practice cannot be tolerated, obviously for reasons of public policy. Furthermore, it has been held that after voluntarily submitting a cause and encountering an adverse decision on the merits, it is too late for the loser to question the jurisdiction or power of the court. And in another case, the court said that it is not right for a party who has affirmed and invoked the jurisdiction of a court in a particular matter to secure an affirmative relief to afterwards deny that same jurisdiction to escape a penalty. The court frowns upon the undesirable practice of a party submitting his case for decision and then accepting the judgment only if favorable, and attacking it for lack of jurisdiction when adverse. In the case of Heirs of Bautista v. Lindo, GR number 208232, March 10, 2014, the Supreme Court held aside from belatedly filing the motion to dismiss, which is 9 years after the filing of the complaint, respondents actively participated in the proceedings. In what way? 1. By filing answer and opposition to the prayer for injunction, interposing counterclaims. 2. By participating in pre-trial. 3. By moving for the postponement of their presentation of evidence. 4. By presenting their witness. And 5. By submitting the compromise agreement for approval. So the Supreme Court held in that case that having fully participated in all stages of the case, and even invoking the RTC's authority by asking for affirmative reliefs, respondents can no longer assail the jurisdiction of the said trial court. Simply put, considering the extent of their participation in the case, they are, as they should be, considered stopped from raising lack of jurisdiction as a ground for the dismissal of the action. Estoppel by laches. The exception to the basic rule mentioned operates on the principle of estoppel by laches, whereby a party may be barred by laches from invoking the lack of jurisdiction at a late hour for the purpose of annulling everything done in the case with the active participation of said party invoking the plea. So in the oft-cited case of Tiham versus Sibong Hanoy, the party surety involved the jurisdictions of both the trial and the appellate courts in order to obtain affirmative relief, and even submitted the case for final adjudication on the merits. It was only after the Court of Appeals had rendered an adverse decision that the party surety raised the question of jurisdiction for the first time in a motion to dismiss almost 15 years later. However, in subsequent cases, the Supreme Court held that Tiham is only an exceptional case. The exceptional circumstance involved in Sibong Hanoy case, which justified the departure from the accepted concept of non-waivability of objection to jurisdiction, has been ignored, and instead a blanket doctrine had been repeatedly upheld that rendered the supposed ruling in Sibong Hanoy not as the exception, but rather the general rule, virtually overthrowing altogether the time-honored principle that the issue of jurisdiction is not lost by waiver or by estoppel. Now let us discuss cases when estoppel by laches does not apply. Cabrera v. Spouses Clarin, GR number 215640, November 28, 2016. The facts of this case are as follows. Respondents raised the issue of lack of jurisdiction in their motion to dismiss filed before their answer. Respondents raised the issue before there was judgment on the merits in the trial court. Respondents never assumed inconsistent position in their appeal before the Court of Appeals. So the Supreme Court held that the unfairness and inequity that the application of estoppel seeks to avoid espoused in the Tiham case are not present in this case. The instant case does not involve a situation where a party who, after obtaining affirmative relief from the court, later on turned around to assail the jurisdiction of the same court that granted such relief by reason of an unfavorable judgment. Respondents did not obtain affirmative relief from the trial court whose jurisdiction they are assailing, as their motion to dismiss was denied, and they eventually lost their case in the proceedings below. Tumpag v. Tumpag, GR number 199133, September 29, 2014. The Supreme Court held in this case, we rule that the respondent is not stopped from assailing the RTC's jurisdiction over the subject civil case. Records show that the respondent has consistently brought the issue of the court's lack of jurisdiction in his motions, pleadings, and submissions throughout the proceedings until the CA dismissed the petitioner's complaint not on the basis of a finding of lack of jurisdiction, but due to the insufficiency of the petitioner's complaint, that is, failure to allege the assessed value of the subject property. Even in his comment filed before the court, the respondent maintains that the RTC has no jurisdiction over the subject matter of the case. Void judgment. A void judgment for want of jurisdiction is no judgment at all, and cannot be the source of any right, nor the creator of any obligation. All acts performed pursuant to it, and all claims emanating from it have no legal effect. A judgment rendered by a court without jurisdiction is null and void, and may be attacked any time. It creates no rights and produces no effect. It remains a basic fact in law that the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all, and again, all acts performed pursuant to it and all claims emanating from it have no legal effect.